Welcome back to the Men's Divorce and Cordell video and podcast. I'm Scott Trout, CEO and managing partner of Cordell Cordell. We continue to bring you the latest information on COVID-19 and how it's affecting guys in family law before, during, and after divorce. And today is no different. We want to bring you information on child support, and we're going to Connecticut and one of our attorneys up there. Welcome, Alex.
Hi, Scott. Thanks for having me today.
Well, thanks. I know that when we look at the unemployment numbers, 36, 39 million unemployed, it's crazy. We know that within there, we're probably talking 9, 10 million guys have issues about child support, about spousal support, whatever it is, modifications in general. And so we wanted to bring, I know you wanted to talk a little bit about it, and I think this is ripe for this conversation. But before we do that, obviously, we want to make sure that guys understand that this isn't an attorney-client relationship. We don't want to give legal advice here. I'm not licensed in Connecticut. I'm only licensed in Missouri, Illinois, and Georgia. And so obviously what we're talking about is educational and informational. We want you to write these things down and take it to an attorney and really use these as discussion points and talking points to get the legal advice that you need. But typically we do this to make sure guys understand what they can do, what they should do, and what they must do. And so write these down, get to a lawyer, and if you need to consult with us, wherever you are, as you know, we're across the country, including the UK. You can reach us at 866-DADS-LAW or at the web, cordellcordell.com. All right, so let's talk about child support in Connecticut, but I think maybe as we did last time when you joined on the podcast, let's talk about the status of Connecticut courts now, what's going on. So guys know, before we talk about modifications and child support calculations, what can they do in Connecticut right now?
So we're still on a pretty heavy shutdown in the courts. They are opening up things such as status conferences and family law pretrials through an online video conferencing thing. And that platform seems to be working to try to work through some of the log jams, but anything that requires a hearing is not being scheduled. I think the first one that I have seen so far is actually in August. Wow. I think that they are going to try to do some stuff in June and July, but I think the June piece was very hopeful. At least that's what we're hearing from judges. They are processing, however, agreements. So, for example, I have several divorces that could go to judgment, and they've created now a way for us to have a final judgment approved, and that applies to post-judgment matters as well. So if you can reach an agreement on something like, what we're going to talk about today, the child support modification, we could actually get that agreed and done. If there isn't an agreement, then there's going to be a delay with that.
Yeah, it's, that's kind of happening around the country. We have pockets in our Cordell offices where the courts are open and they're taking, cases as we go. But, it doesn't mean that they can't file something and at least get in line or come to an agreement, right?
That's absolutely correct. One of the things that's really important is the sooner that you file, the sooner that the retroactivity kicks in if you can't reach an agreement. So, for example, if the money that you pay for child support number is that's going to go down, you want it sooner rather than later to protect that date of filing. So it will go back to the date of filing as opposed to the date that you get into the court.
Yeah, and retroactivity is such a hot topic, and it's so important for the 10 million guys who are struggling to pay the court-ordered amounts, or even amounts that aren't court-ordered, and they're in the middle of a divorce. And, that kind of blends us into the question of guys want to know, they filed for divorce, but they don't know how child support is going to be calculated. So maybe you can talk a little bit about Connecticut. I know there are guys listening right now in your state and the surrounding areas, and they want to know, how is my child support going to be calculated? Maybe start us off with the basics. Is there a calculator? Is there guidelines? What is it, and how do they start calculating it?
Yeah, so in Connecticut, it's based on an income shares model. And so what they look at is the gross income of the parties. There are small credits for things like who is paying, the health insurance for the family, or, what each party pays for that if they're paying for their own. And they really just look at gross income. That's it. And then the calculation is based on a set of guidelines, and you put it into a program, and it tells you, based on what your gross incomes are, what the percentage or share of the amount that should go to that child, of support that should go to that child. So it could be, a 50-50 split if your incomes are relatively close. It could be completely different if there's a major disparity in the incomes.
So now with COVID, obviously, you may have an entirely different situation. So how do you think courts are going to look at this? I mean, I think I've likened it to the recession back in the, the early 2000s, mid 2000s in terms of, guys losing their job, furloughs, pay cuts, bonuses aren't coming around, stock options, whatever it is, over time, they're not getting it. So how's the court going to look at income, post COVID? If they're, at the start of the divorce, they were making 50,000, now they're making zero. What's the court going to do with that?
So I think you have to look at the circumstances as they stand at the time that your order is entering. Okay, so if at the time of the divorce someone was making a lot of money, and then now in this current situation they're greatly reduced by whatever percentage, or they're not making anything, the courts are going to look at the salaries as they stand at the time that you're seeking the modification. You have to be able to show to the court a substantial change in circumstances, and that typically ranges in like the 15% mark. So if you're looking at a change in income, if it's greater than 15%, at that point you probably have exactly what you need, at least to meet that initial step of, is there a substantial change in circumstances from the prior court order? Mm-hmm. And so you have to take a look at that. If it's within the 15%, you need to sit down and run the numbers and find out whether it's really in your client's best interest, to do that. But if they're not working at all, obviously that's a huge difference. And we'd have to look at it at that point.
Yeah. And I think the message I've always told guys is, look, no court, they're going to be reasonable. Back in the recession, I found that the bench was very reasonable when we had guys losing their jobs with no prospects of not getting anywhere close to the income that they once had. And, typically either you had, a guy coming in who may be middle-aged and the prospects of employment are just very slim. And so they were reasonable. And I think the results we saw from the orders were fair. And I think that's what guys want to hear is that, look, the courts are not going to just impute, say you're making 100 grand before COVID and 50 grand now, they're not going back to 100 grand. Most aren't. And I think there's legitimate reasons, arguments to make to ensure that we, that's why it's important to get to a lawyer and start planning. One of the interviews I did back in like 2008 with Wall Street Journal was they said, hey, guys can't afford to file for divorce because of the recession. I said, well, guys can't afford not to file because here you want to file at your lowest point, because if we're going to use income and the court's going to actually take your lowest income to calculate it, let's do it now. Rather than wait till you rebound, wait till you get another job at the previous salary. It's a cost-benefit analysis, and I think that's important when we calculate the child support. So, go ahead.
Child support is always modifiable. So if where you are, in your particular circumstances are, like you said, down 50,000 at this point, who's to say in 6 or 12 months time, if we bounce back, then you can go back and modify it again if you need to. But particularly, you need to look at the circumstances as they stand. Yeah.
So always ask the question, guys say, does it matter when they calculate child support? Does it matter how much custody time I get in an order? Does it matter who the primary parent is? Are there discounts, deviations, adjustments if we split the time? Kind of, how does it work in Connecticut based upon the custody agreement?
So they changed the laws several years ago in Connecticut, and what they do now is there is no discount for a shared parenting plan unless you agree to that discount, or they call it here a deviation. And essentially what it does matter is who, the person who earns the most money or earns the higher income is the one who pays child support. And it doesn't really matter about the parenting plan itself, unless someone has more parenting time, or like primary residence is what we call it. So whoever has the primary residence of the children is the one who receives the child support. Now, if that person happens to be the higher income earner, then obviously the child support comes the other way, but it's going to be, a lower number, because they're the higher income earner.
So are there ways and possibilities to argue in a trial if you can't come to an agreement on deviations in Connecticut to say to the judge, hey, we need to deviate from the calculated amount because, I've got more time, I have more travel, whatever it is, I have more costs I incur because of our shared custody. Can you argue that?
You can't argue it. So again, if you can't reach an agreement on the deviation, the factors are, well, it truly is a shared parenting plan and, our incomes are, roughly similar, or, that's one argument. Or I have travel expenses because I live out of state, so I should get a little bit of a discount because I have to travel further to, exercise that visitation with my children.
Mhm.
So there are reasons to deviate. There's a whole criteria, that the Connecticut judiciary has set out, that we can look at for those deviations. That's just, a couple of examples.
And I think that's the thing that guys want to hear is they don't want this to be this automatic process that becomes very simplified and ignores the facts, meaning that here's your number, here's what you make, here's your child support, go home. And they want to know that, and that's our job, is to alert them to the potential legal arguments, to argue deviations that could be supported by facts, and to go into it. And I've always said that's where we talk about unapologetically stepping on toes. And the point is, look, if our client has equal time and there's a legitimate legal argument to make that we should deviate, we need to do that. And that's what guys want to hear, in terms of what their rights are. So I guess then the question becomes, in Connecticut, is daycare included in the child support calculation, or private school costs, health insurance? What's in there besides just this income, magical number using your income?
All right. So daycare and unreimbursed medical and dental expenses, in addition to the actual just support obligation, are the only things that are covered. So the way it works is that income shares model calculation spits out a percentage. And so what they'll say is, okay, here's your child support obligation. It's, $125 a week, for example. And then the income shares models percentage says, the high income, payor pays 72% of any, daycare costs, and, the other party pays the remainder. And the same goes for unreimbursed medical and dental. So co-pays or, hospital costs, things like that.
Yeah.
Those are the only things that are covered under the child support guidelines. Education costs, for example, any sort of private schooling, or even if you're thinking beyond, once they're beyond the child support piece, educational support, college, completely different, completely separate.
And I think that's important for guys to know that if they're not in Connecticut and they may be in a state, for example, like Missouri. Missouri does have a shared income model, but what's included in that child support number is not just a percentage, but it's the daycare is added into the chart. And let's just say it's $500 a month. Well, if it's equal income, basically they're attributing 50% of that daycare in the child support number. And the danger of what we call including it in the child support number is if at some point that child support or that daycare goes away, you have to actually file a motion to modify in order to get rid of that daycare. Oh, wow. And it's dangerous. And so I think that's why I always talk about one of the things that guys need to be looking for is if you're in a state in which daycare is included, you need to go off chart, meaning you need to pay that like Connecticut, where it's just a percentage. You all pay 50% of the daycare that's incurred. So it saves you attorney's fees on the back end. A lot of guys don't think about it. They aren't advised of it. It's a huge savings because otherwise you're coming back and spending thousands of dollars just to get rid of that daycare that maybe the other parent isn't incurring for months and years. And right. So just kind of I always ask that question because I always found Missouri to be unusual. Connecticut seems legitimate that, here's the percentage, you just pay it so long as it's incurred. It's a nice formula, right?
Yeah, so, and I think that a lot of times when you're looking at incomes and, if they're substantially similar, a lot of parties will just agree, hey, look, let's just split it 50-50. Both parties have some, skin in the game, so to speak, but then, we can look within those numbers and see what we can work with for sure.
Yeah.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
So then we talked, I know you alluded to it earlier about a modification. And I talked about this in the virtual town hall about 3 weeks ago that we hold on Thursdays. And we've used the word substantial change of circumstances. So in Connecticut, what does that mean? If I'm a guy, I've been divorced, I think I need to modify my support. What do I need to prove? And what does that mean?
So a substantial change in circumstances is proving that there is a change in what was in place at the time of the first or prior orders and your circumstances now. So for example, the loss of a job would obviously be a substantial change in circumstances. A drastic reduction of income, like we talked about earlier, 15% isn't necessarily, if it's under 15%, that's not necessarily the biggest change. And we'd have to sit down and again run the numbers on that. But any sort of significant increase or decrease in any kind of numbers like that would warrant a substantial change in circumstances. The other piece would be a change in the parenting plan. So I've had several cases where, primary residence was with mom, and so dad was paying child support. And then, one or more of the children said, I don't want to be here. I want to be with dad. Can we, swap it around? Well, we reached an agreement, but that obviously means that, the child support has to change.
Yeah.
Sometimes that has to be because the kids are spending more time, maybe not by agreement. And we've got to go and argue the point that, look, now there's a change, and now we've got to really look at these numbers and make sure that we're protecting our clients that way.
So there's guys I know that have asked me, and it does apply in Missouri, divorced, and their income has been relatively stable or maybe just a little bit down. And they always say, well, I think my wife at the time of the divorce, she wasn't employed, but I'm pretty certain she got a really nice job. And does a change in the recipient's income in Connecticut matter? Meaning that if a guy comes in and says, I think she went from 0 to 100,000, would that be enough? Or if you can prove it, obviously, is that considered a change in circumstances for Connecticut child support?
It is. I actually have a case going right now that's exactly that. And the question is, how much of an income difference is it? And if you said, like your circumstances, it was 0 and now they're earning 100, well, obviously that's a massive change, and it's definitely worth filing that. If there isn't an agreement, then we file the paperwork and we have to go to court and, get the proof that we need in order to prove that change. But absolutely, the case of whether or not, again, there's a massive change in that income, that's where you sit down and you have a discussion with the client and find out, if this is appropriate and if that change really does exist. And more often than not, it does.
Yeah. And it's hard. I mean, guys say, well, how am I going to know? And I know it is a little risky. And I've always encouraged guys to keep the lines of communication open. And it's not as threatening. And you'll be amazed at what information you get from your ex-spouse in terms of their situation, their finances. Hey, yeah, things are better. How's your job search going? This is a tough time. Oh, you got a new job. Congratulations. What are you doing? You just get a lot of information having that conversation. You'll feel a lot more comfortable moving forward in a motion to modify that you ultimately have to get the proof anyway. But some guys don't keep those lines of communication open, and it's a gamble. It's a roll of the dice because they really don't know. And so it's a good conversation piece, obviously, as you suggest. Come in, let's do the calculations. Let's what I do for my clients is best case, worst case, most likely, and give them those options based upon the information they have. And then they can make the decision, and we talk about cost and which is interesting. And so thanks for joining on this child support information. It's a lot of information I know that guys wanted.
Yes, thanks for having me.
And so talking about the child support, one of the things you should inquire if you want to consult with us is we have this max cap fee program out there on child support modifications, meaning that the age-old question has always been, well, what's this going to cost me? And now we've rolled out a program during COVID-19 that we can answer that question and say, okay, if you have a child support modification because of a loss of a job or decrease in income, here's the maximum amount of attorney's fees that you're going to spend. And it's a wonderful program. I'd encourage you to reach out to an office near you at Cordell Cordell at 866-DADS-LAW. Find out more information about it. It's a really great program, especially during COVID-19 for guys who need to modify their child support. So as always, thanks for joining. Continue to tune in every day as we talk about specific issues like child support today during COVID-19. Tune in on Thursdays during our virtual town hall where you can join in live, ask questions of the panel, and get answers. Reach out to us at 866-DADS-LAW or CordellCordell.com. Until next time, have a great week.